heard, usually the opportunity to be heard should come before the deprivation, and you should have a fair and impartial decision maker. Now, to start, you need to understand what procedural due process doesn't cover. Procedural due process does not apply, this business about notice, personal notice and an opportunity to be heard does not apply when the legislature is taking action that harms you. It applies when the government is taking adjudicative or administrative action against you or an identified number of people. For example, let's say the government passed a law that eliminated welfare benefits. Not such a hypothetical case anymore, I guess. And let's say you were a welfare beneficiary and you lost your welfare benefits. Surely you're harmed, you've lost, you could argue that you've been deprived of property, but the government doesn't have to give you any specific procedures. It's enough that this generally applicable statute was passed under procedures that apply to the legislative process. Consider in contrast a situation where the government does have a welfare program and you are a recipient and the government agent comes over and cuts you off. In that kind of a case, since there was already a welfare program, governments don't have to have them, but there was already one, and since you already applied for and were getting welfare, you're entitled to notice an opportunity to be heard in terms of determining whether the official who threw you off the welfare rolls could do so under the law. But simply legislative harms are not ones that will trigger rights of procedural due process to personal notice and an opportunity to be heard. You can also think about it. It would be kind of ridiculous. Every time some statute would affect lots of people, they would have to get personal notice and opportunity to be heard. Okay. Now, in terms of triggering procedural due process, we ask what we mean by deprivation of life, liberty, or property interests. Well, in terms of deprivations, we mean that the government is harming you in some way. But it has to be that the government is harming you in an intentional or deliberate way. If the government injures you merely by negligence, the court has said, that's not enough to trigger procedural due process. You may have a tort suit against the government, but it's not enough to trigger procedural due process. And so, for example, in a case where prison officials negligently injured an inmate, the court said there was no deprivation under procedural due process because the prisoner could sue in tort, but he didn't suffer a constitutional injury. Now, deprivations can include temporary losses. It doesn't have to be permanent losses. For example, in the debtor-creditor context, let's say the government seizes your property. The sheriff goes out and seizes your property. It's not your own self-help, so we have state action. And they seize your property by way of an attachment for a lawsuit so that there's property there to satisfy the judgment if you lose. But we're only holding it temporarily to see who wins the lawsuit. Is that temporary loss? Is that still a deprivation? Yes. Even a temporary loss can count. And it can even count if you're deprived of things you don't own, that you only possess. Again, the debtor-creditor context provides an example. Let's say the sheriff, again, a state actor, seizes property that a person is leasing or maybe purchased on installment plans but doesn't actually own. And if that's being seized, let's say again in an attachment procedure, it still counts even though you don't actually have title. It can be as to things you merely possess. However, what do we mean by life, liberty, or property interests? What counts as a life, liberty, or property interest, the deprivation of which will trigger procedural due process? Well, if the government's going to take your life, that's pretty obvious, so we don't have to spend any time on that. But questions of liberty and property can get tricky. And the reason why they can get tricky has to do with the case